I'll move the approval of those minutes. Is there a second?
Second.
Any discussion? All those in favor?
Aye.
Opposed? Abstentions?
One abstention.
One abstention, and the motion carries. Next item on the agenda is the report of the chair. So good morning and welcome to the February 8th, 2018 public meeting of the New York City Campaign Finance Board. On January 29th, the board held a public hearing to discuss New York City's 2017 elections. The board holds such a public hearing after each citywide election cycle to help evaluate the impact of its work. We received feedback from former candidates and their campaign associates, campaign finance experts, good government groups, partner organizations in our televised debates program, and members of the general public. We sincerely thank each person who took the time out of their schedules to offer their perspectives on the program. Anyone who wishes to submit testimony may still do so by sending an email to our public relations staff at press@nyccfb.info. The board will review your testimony and it will be posted to the CFB's website. This feedback will be taken into consideration as we prepare our post-election report, which will be published in August of 2018. I'll now turn to our Voter Assistance Advisory Committee Chair, Naomi Zauderer, for her report.
Thank you, Chair Schaefer. Last month, NYC Votes staff participated in the annual homeless outreach population estimate on January 22nd through our ongoing partnership with the New York City Department of Homeless Services. This citywide volunteer community effort is held each year to count the number of New Yorkers sleeping on the streets during the coldest time of the year. After all, we want to ensure that all eligible New Yorkers have the opportunity to register to vote, and that includes our city's most underserved populations. We are thankful for our relationship with the DHS to help make that a reality for our city's homeless community. As you all know, February is Black History Month, a particularly poignant time to honor the legacy of voting rights champions like Fannie Lou Hamer and Medgar Evers. As we honor those heroes, NYC Votes recognizes that the fight for voting rights continues. And so we are launching a new statewide petition calling for election reforms, including early voting and automatic voter registration. One of the bills we're supporting would reinstate key protections from the Voting Rights Act of 1965, requiring pre-clearance from the New York State Attorney General before making changes to the voting process in counties with racial, ethnic, or language minority communities. This advocacy effort builds on the groundwork laid by so many African-American civil rights leaders throughout our country's history. But if these reforms are going to have a chance to pass, we need as many people as possible to add their voice in support. That's why we're calling on all New Yorkers to add their names to the petition by visiting votebetterny.org. And lastly, we will be holding our next VAC meeting on Tuesday, February 13th. Please come and share your ideas of how to improve elections in New York City. And with that, I'll turn to CFB Executive Director Amy Loprest for her report.
Thank you. I just want to acknowledge some recognitions that our staff has received. In two annual summary publications, the work of NYC Votes and the Campaign Finance Board was recognized both in Nation Builders annual publication summarizing their initiatives throughout the country and in the National Voter Registration Day annual report of activities on National Voter Registration Day. So congratulations to the staff who are instrumental in implementing those initiatives. Also, Matt Sollers, our Director of Public Relations, presented our Follow the Money disclosure system at the National Unrigged Democracy Conference, which was held last weekend in New Orleans. His presentation was well received. A lot of people very interested in our public matching funds program and in our disclosure regime for independent spending. Also this week, the District of Columbia passed a public financing bill, which is similar to our public financing system. So that was passed this week, and they're waiting to see if the mayor of DC will be signing that bill. And again, if imitation is the sincerest form of flattery, we should be proud. The city of Arlington, Virginia is holding a voting sticker contest, which is very much based on the every 4-year contest that we hold to determine the sticker that we give out to voters on election days. So thank you for all the staff who worked on that sticker contest, because it's very widely popular throughout the country, obviously.
Thank you very much. We have one matter for hearing today, and that concerns the independent spending by Michael Ricotta. I understand there's an attorney present for Mr. Ricotta, so why don't you come up and have a seat at the table, and CFB counsel over here. The CFB counsel go first and sort of tee up the issue briefly, and then we'll be happy to hear from you.
Good morning. My name is Bethany Persky, Deputy General Counsel for the CFB. Before the board is the matter of Michael Ricotta, an independent spender in the 2017 elections. CFB staff is recommending that the board find that the independent spender committed the following violations: failing to file, that's 3 instances, and use of a paid-for by notice that is incomplete, 7 instances of that.
Okay, please introduce yourself. You're welcome to stand if you like, but you need not.
Can you turn on your microphone?
And
If you
press the button, so it turns green. Now you're set.
Hello, I'm Mark Demetropoulos representing Michael Ricotta. He couldn't make it today. He's a resident of the state of Florida. Basically, this matter is he's a independent person. He's not a professional fundraiser or anything. He's a businessman. He lives in Florida. He was aware that a Robert Holden was running for city council, and he was last minute added to the ballot. And Mr. Ricotta did not wanted to express his political opinion. So when he learned that Mr. Holden was running for office October 1st, he had about a month to voice his opinion. So he basically ran a few ads. One of them was a couple of newspaper ads on November 2nd, and 2 robocalls, one on October 31st and one on November 3rd. And he wrote his he basically put in the ads paid for by Michael Ricotta. He thought he was expressing his political opinion. He later found out that he was deemed by the CFB board as an independent spender. He had a representative in New York attempt to file, and because of the cumbersome, burdensome filing procedure, his representative had trouble filing. It later got filed, but got filed late, and I believe that's where the fines came from. I don't believe he should be faced any fines. He was expressing his political opinion, and some of the past cases, U.S. versus McIntyre, Citizens v. United, they really establish it's a strict scrutiny standard that when one's expressing their core political values, they shouldn't be burdened with any cumbersome regulations. And in fairness, the CFB registration process is very cumbersome. If you notice, they actually have a training manual, but that training manual procedure had expired by October 10th, and that would have given him almost less than 10 days after he found out Mr. Holden was running for office. When he decided to express his political opinion, he really didn't have time to go through that training manual. So Mr. Ricotta really does not believe he should pay over $6,000 in fines. That is excessive. So he's on notice. So if he does it again, he'll file a procedure. So Mr. Ricotta is asking that the fines be reduced to 0, respectfully. And just to go on record, I just handed you all copies of my statements.
Yes, thank you. We do have copy of your statement, and that's very helpful. I'm not going to address the legal argument. I think we're well satisfied that the statutory scheme that we administer is constitutional in requiring the reporting of independent expenditure. I think the principal issue concerns the circumstances under which the registration failed to happen, and I'll ask if CFB counsel would like to add some detail to that issue.
Sure, I would
And
just,
if I could add, when you're doing that, I want to, which things were, I want to be clear, what was included when something was filed on November 7th and what was not included until much later?
the only thing that was included in the November 7th filing was the mailer. The robocalls, the print ads, and the robocalls and the print ads were not properly disclosed until the December 4th filing.
But back up a little bit and
Sure.
talk about what happened on November 3rd, 4th, and 5th.
Right. So the first instance of CFB staff contacting Mr. Ricardo was on November 3rd after staff learned of the print ads. And then CFB staff was contacted by Maureen Daly, who was representing the spender. She was given extensive assistance by CFB staff over the course of several days, including an in-person meeting at the staff offices on November 6th. In terms of the glitch that Mr. Ricardo was alleging interfered with their ability to report, this was not an issue with the disclosure system process. What happened was that Ms. Daly already had an account in the system, was attempting to set up a new account, but it recognized that her email address was already associated with an account. And so when she was entering her password, it wasn't allowing her to create a new account. Our independent expenditure disclosure analyst, Zach Holden, spoke with her over the phone, explained that that was the issue, attempted to talk her through the process. I believe she also spoke with Jesse Schaefer, our director of special compliance. Again, over the course of several days, there were a number of phone calls, email exchanges, attempting to explain to her what the problem was. She then came in on Monday the 6th and was walked through the process by staff, and then was not able to actually report on that date because there was a form that she had to obtain a signature for and come back and file. So the actual filing was not complete until the 7th. And again, that filing only included the mail and not the print ads or the robocalls.
I'm intrigued by the phrase attempted to explain to her. Could you, I'm not very good at this stuff myself. Some other members of this board are. So what was the solution to the problem that the system recognized her email address and that therefore it sounds like a couple additional steps needed to be taken? And why was it so hard to explain this or effectively communicate this to Ms. Daly?
If I may, do you want to? Mr. Holden is here, and he was the one who actually participated in these conversations, and so I think I'd have
That would be very good. Thank you.
So if you look at exhibit,
Identify yourself for the.
this is Zachary Holden. I'm the independent expenditure analyst and liaison for the Campaign Finance Board. So if you look at exhibit D of the penalty notice, you'll see an email that I sent to Ms. Daly on November 5th.
You use the microphone, please.
Yes, sorry. If you look at Exhibit D, there's an email I sent to Ms. Daly on November 5th, in which I...
Slow down. Let me just find it here. Looking for, that's B. Okay.
It's page 9 of the penalty notice.
Got it. Thank you. Okay. Got it.
So yes, the eventual solution was to enter a different email address because as Bethany hit upon, there was a issue with the email address she was using already being associated with an account. So I gave her that solution on November 5th, and she said that it didn't work, and then she came in on November 6th, and I performed the procedure I described to her. So in terms of attempting to explain to her, this was a pattern of I'd provide her with technical solutions, and then there wouldn't be a response immediately until I repeated it.
So in other words, on November 5th, you gave her the solution of using just a different email address, which
Yes.
and apparently she had one. And did she ever explain to you why, what the problem was in just entering that different email address on November 5th?
No, she said, I feel like I've tried everything. I'll stop by tomorrow morning.
And then on November 6th, that you were able to do this with her without any issue?
Yes.
But what was the last day that the filing would have been timely?
It's 3 days or the date of the election, whichever is earlier. The election was held on November 7th. So depending on the date of the individual expenditures, and you can see the chart on page 3 of the board memo has the due date for each of them. The robocalls from October 31st would have been timely on November 1st. The mailers and the print ads from November 2nd, the failure date was the 6th. And then the robocalls from November 6th or 5th, the failure date was the 7th because that was the date of the election.
So so there's a second problem, which I'm going to ask you to address in a minute, which is that she files on November 7th, but that filing is incomplete.
Yes.
Okay. Would you like to address that?
Just from what I heard from Mr. Ricotta is that his representative kept trying to file online, and they just had trouble attempting to file. So it wasn't able to go through. They did try numerous times. So,
right, but if she had filed on November 7th and it had been complete, you would, it seems to me, have a somewhat stronger argument in saying, well, look, a couple of these are a little bit late, but she had trouble filing. Some of them are timely, but in any event, she got it all down on the day of the election. But on November 7th, she files and she completely omits, relevant information.
I don't believe that was done on purpose. I believe they made a good faith effort to try to file. It's not like they didn't file. So Mr. Ricotta's also general purpose is to at least, they don't believe the fines that were levied were really adequate for what happened. He attempted to voice his opinion.
More than that.
Yeah, exactly.
What is the basis for your saying that it was a good faith mistake that they they excluded virtually all of the independent expenditures and only filed the smallest number? What is the basis? I'm just curious. What is the evidence that you have that that was good faith?
I just believe his representative tried to file timely.
Let me ask another question. I mean, when I look at some of you say he's a resident of Florida?
Yes.
He's a businessman?
Yes.
And one of the...
He did it of his own free will. He wasn't coordinating with any political party.
I understand. But one of the independent expenditures includes his name, but gives a Kew Gardens address. Is there a reason that he didn't disclose his true residence and put in a residence which probably was in the district?
Not that I'm aware of, no.
But you say he's a resident of Florida. Now, how were the various communications designed? I mean, who designed them? Was he involved in that?
I believe he did.
Excuse me?
I believe he did. He designed it.
Because when we look at them, even where it says paid by, it looks like it's designed in a way to almost make it, I won't say impossible, but very difficult to see and very easy to miss. Do you have any explanation?
So you're insinuating that he made it misleading. I mean, he didn't believe it was misleading, but I mean, one could interpret.
Well, let me ask a question about that coming sort of from the other perspective, which is he's got a paid-for notice, and it's sort of in a box. Did he understand when he did that was required by our law and regulations?
I don't believe so. I think he just did it to show transparency.
Okay.
Because the box is one of the things that's in the regulations, so it's a little surprising that he would include one of the things that's in the regulations but not other things that's in the regulations.
Well, he's not to my knowledge, he's not an expert in the campaign finance laws.
Are there other questions by members of the board? Do you have anything further you'd like to say?
No, just that if the fines could be reduced, that's all he requests.
What is that address in Kew Gardens, by the way? Is that a residence? If you know, is that another residence of his? Is that?
Unless he owns property, I'm not aware of that. I'm not aware of that. I don't know.
Okay, does the CFB staff have anything to add at this point?
No.
Okay, well, thank you all very much. We will,
Thank you for having me to speak.
you're most
Thanks.
welcome, and we will go into deliberations at this time.
Thank you.
Thank you.
Thank you.
All right, so we're back in open session. And before announcing our decision with respect to the penalties for this independent spender, I just like to, we don't usually do this, but there are a couple facts that didn't really get highlighted in the earlier discussion on this matter, and which are relevant to our consideration. So I'd just like to mention them. The record in this case indicates that there's an invoice from Gotham Strategies for their involvement, presumably in the design and placement of the ads and robocalls and mailings. Gotham Strategies, of course, is an entity that has done work on other campaigns and has been involved in CFB proceedings before, and presumably knows full well what the law and regulations are in this area, and they were involved from the end of October, according to the invoice. The other fact, which I guess did come out but is worth emphasizing, is that the filing that was made on November 7th referred to the mailers, but not to the advertisements or the robocalls. So with those facts in mind, we're going to propose, subject to the vote of the board, the following resolution of this matter. This is the independent expenditures by Michael Riccado. And with respect to the alleged violations 1 through 3 for failure to file, the recommended penalty is $1,980. And with respect to alleged violations 4 through 10, the use of paid-for by notices that are incomplete, the recommended penalty is $2,400 for total recommended penalties of $4,380. I'll move the adoption of those recommended penalties. Is there a second?
There's a second, Mr. Chairman, but I thought also in terms of the penalty for the late filing, that was computed by deducting the cost, the $2,800 for the cost of what was included in the November 7th filing, and then applying the percentage to the reduced amount.
Yes, that is in fact the methodology that we used in the reduction of that penalty. So it's been moved and seconded. Is there any further discussion? If not, all those in favor? Aye. Opposed? Abstention? The motion carries. I think that is all. We're going to vote now to go into executive session, but I'll take this as a dual motion to also adjourn since we have no further business in open session. So I move that we go into executive session and then adjourn. Is there a second?
Second.
All those in favor?
Aye.
Opposed? Abstentions? Thank you all very much.